I'm just having a little computer issue here. It's just gonna be one moment, everybody. I'm sorry. There we go. Okay, we'll go on the record in People versus Gilbert Del Bosque. This is file number 256921. The record should reflect that Mr. Del Bosque is present today by video from the Otsego County Jail. If I could have both counsel put your appearances on.
Good afternoon, Your Honor. Mike Rolo from the Otsego County Prosecutor's Office on behalf of the state.
Thank you, Your Honor. Richard Church appearing on behalf of Mr. Del Bosque.
Right, and then I see we also have Mr. Brunical connected. He's the probation agent that is supervising Mr. Del Bosque on probation. Mr. Del Bosque, my name is Judge Mertz. I'm conducting this hearing today on behalf of Judge Hunter. You're before the court today for arraignment on some alleged probation violations. Have you been made aware of what the alleged violations are?
Yes, Your Honor.
Okay, and Mr. Trush, did you have an opportunity to speak with Mr. Del Bosque about how he wanted to plead today for arraignment?
I did. I had an opportunity to speak to him this afternoon. We went over what the specific allegations were, as well as the difference between technical and non-technical violations. I discussed with him his different options. At this time, we'd waive a formal reading of those allegations, stand mute to those charges, and he would qualify for counsel. I have relayed that to the appointing authority, but I don't know who's going to be appointed. I would assume the same attorney who represented him on the underlying charge. We would ask the court to set a hearing at the next available date, and we would like to address bond.
Okay, so the court will enter not guilty plea on behalf of Mr. Del Bosque with regard to each of the alleged probation violations. The court will sign the order requesting appointment of counsel. So Mr. Del Bosque, you'll be notified of which attorney is going to be appointed for you to represent you. In terms of any bond pending that hearing, Mr. Rolla or Mr. Brunical, either, do you have any input on that?
Judge, as to bond, we have a situation where the court's well aware the defendant is on probation for his third domestic violence. We also have now a pending operating while impaired situation with this gentleman allegedly having occurred. Let's see. Give me a moment, Judge. My system's being a little slow now. Apparently it's getting tired at the end of the week.
While we're waiting on that,
I'm sorry, Judge, I didn't interrupt.
Go ahead.
Apparently for an incident that looks like it took place on August 17th, 2025. In any case, conditions of his probation are that he's not supposed to drink, that he's not supposed to commit any acts of violence. I understand the basis of this is regarding the argument of with his wife on January 29th, 2026. So that would be the basis for the violation, because the other offense would have occurred prior to him being placed on probation in the circuit court.
Okay, thank you. Mr. Brunical, as the supervising agent, anything you wanted to add?
Yes, Your Honor. On January 26th, he was arrested consuming alcohol. He was a 0.3 at the time. That violation was processed and he signed acknowledgement of that. Now this one comes a couple days later. Argument with his wife. Officers were called to the residence. Upon booking, he was a 0.31. So the department would be recommending a substantial bond in this case.
All right, thank you, Mr. Trush.
Thank you, Your Honor. I would suggest, and I think everyone's kind of hit the nail on the head here with the alcohol. I think alcohol is a problem here. I would suggest to the court, I don't know that a substantial bond here is necessary. And frankly, I don't know that it does any of the parties any good. What I would suggest to the court is a different path, which is I would suggest to the court placing either a low cash bond or a PR bond in place, but require him to wear a scram tether. I think that that would address the drinking. That would allow him to be able to be home, and allow him to be able to continue to work. He expressed to me when talking to him a great deal of concern about, again, his ability to keep his job, potentially losing his housing, a lot of things that, again, I'm sure the court's well aware of many people before you face. Giving him the opportunity, though, to have a tether assures that he's going to be monitored 24 hours a day. If he consumes alcohol, we're going to know. And frankly, from what he's indicating to me, it sounds like when he's not consuming alcohol, he's not having the types of problems that he is when he is consuming. And again, I don't think that's surprising for the court to hear. I think we see that happen a lot. So I would suggest to the court, I think that it is a better alternative to give him an opportunity for release, but to hold him accountable with a scram tether.
All right, thank you. Yeah, this is not my case, but I did have a chance to review the file prior to the hearing today. And I do note that Mr. Del Bosque was just placed on probation just a couple of weeks ago, at the beginning of January. So, and then I would also note that Judge Hunter, at that sentencing hearing in January, sentenced him to 12 months in jail, but held that in abeyance. So there's a fair amount of time here that the court could order Mr. Del Bosque to serve. And that may be something that Judge Hunter is going to look at. But what's of a greater concern to me is the lack of really demonstrating any real ability to comply with the terms of probation here in just a short period of time. And particularly the use of alcohol, which presents a danger to Mr. Del Bosque and others. And the fact that that's occurred here sounds like multiple times since in the very short period of time that he's been on probation, and already, I think, given a substantial break by having jail time held in abeyance. So I think for purposes of public safety, and for the reasons I've stated, the court finds that a substantial bond is appropriate. I don't have any assurance based on Mr. Del Bosque's behavior since being on probation over a very short period of time that he would comply even with a scram unit, and the potential that he's going to continue to use alcohol and commit further crimes even with the scram unit, I think is certainly a significant chance of that occurring. So the court is going to order a bond in the amount of $50,000 cash or surety. The court will set this for a hearing within the 14 days as required by statute, and notify Judge Hunter of the action here by the court today. I would suspect he'll try and get this case on for a hearing next week during his motion day, but I can't guarantee that. The court will also include all standard conditions of bond and all conditions of probation as conditions of bond. Mr. Rolla or Mr. Brunical, anything further that we need to address here today on the record?
No, Your Honor.
Thank
Mr.
you.
True.
No, Your Honor, thank you.
Okay, thank you. That's all for this hearing today. All parties are free to disconnect. All right, we're back on the record in People versus Moore. And Ms. Moore, have you now had a chance to talk to Mr. Thompson? Mr. Thompson, are there any additions, deletions, or corrections?
You may need to update the jail credit on this, Your Honor. So 16 days is fine, let's do originally. I come up with 18, I don't know what.
Your Honor, Mr. McFarland has 19 days.
Okay, I'll take that.
Okay. All right, so we'll correct the report to reflect 19 days of credit. Are there any other corrections?
Your Honor, my client just advised me that she didn't qualify for Social Security disability.
Okay. Objection to that change, Ms. Coe?
No.
Okay, we'll add that in there.
And that would be it.
Okay. Are there any challenges to the scoring of the guidelines?
No.
Ms. Koch, any additions, deletions, or corrections?
No.
Any challenges to the scoring?
No.
Anybody that wants to address the court today?
No, the restitution request was made and ready, and that was no other victim.
Anything on behalf of the people?
You know, Miss Moore, I never heard from her, and then I just heard from her repeatedly for months. Her blood alcohol was always very, very high. She's 47. She has 19 misdemeanors and 7 felonies. It indicates she has an active probation. That being said, she went to rehab. I don't know whether she completed it. I think she may have left early. I'm not positive how that worked out, but she was in rehab, so that was good. She had repeated drunken disorderlies throughout this community that ended up leading to where we are today. I think the recommendation is appropriate, and I would ask the court to follow it. Thank you.
Thank you, Your Honor. Yes, I spoke about this with Ms. Moore. She thinks she really did get a lot from the rehab program she attended in Saginaw. So she attended and graduated from a rehab
You're
program.
gonna get a chance here in a second.
And then she was released to more of a sober living, halfway house type of arrangement. And that's the facility that she was in, and that ultimately she left. She has a daughter who has a child now. That's going to be her residence when she gets out from whatever sentence the court imposes. She reports to me that her daughters are a really good influence, that her daughter is willing to set boundaries with her and only let her continue to be in that position in the house and helping take care of her granddaughter if she does remain sober. And she advises me she is currently sober and she has been sober. She advises that she was attending NA and AA when she was in rehab, and that she looks forward to using that as part of her recovery strategy. She has a recovery coach that she remains in touch with. And again, she is hopeful that her daughter Justina, by setting those boundaries and holding her accountable, can be a good influence that helps her maintain her sobriety. She understands that's going to be the whole ballgame here. I mean, when you look at the numbers she was blowing on some of these police reports, you know, she's just out in the community at 0.22 levels like that. I mean, Ms. Moore is a tiny person. That kind of alcohol is just very dangerous. And, you know, I'm very worried about her health if that were to ever happen again, but she assures me she's committed to maintaining her sobriety. And so ask the court to consider all that in its sentence. Thank you.
All right, Ms. Moore, anything you wanted to say today?
And I haven't drank ever since I got out of the rehab. And I've been taking care of my grandson. When I went, they blew and I didn't, I wasn't, I blew, no, I wasn't drinking. I've been sober ever since I got out. I chose to go to rehab on my own. Well, they said I had to come and blow every day, but that was a little bit too much for me. And I'm glad that I did go there, because now I got my disability and I can help my daughter now, and I can stay sober. And I'm getting older. I'm tired, and I'm very tired. And I have epilepsy, so I can't do it anymore.
Yeah.
And now I can stay sober and I can pay my fines, and you will never see me again in this predicament.
Okay, well,
And I don't want, to lose my disability, because I will. If I get locked up in prison, I will lose it. And it took forever to get it back.
anything else that you wanted to say?
And I truly apologize. It just, the way that I grew up, and I just want to make a difference, I don't, I want to make a difference in other people's lives and tell them if I quit, I know that they can do it too. It's been hard. Maybe I can be a role model for somebody else.
Well, I read through the report, so I'm familiar with what happened in this case. I'm also familiar with your background and history from all the information in that report.
From drinking. Yeah.
Yeah.
Just let him go ahead, don't interrupt him.
Oh, sorry.
Yeah, it's not really dialogue. You have a chance to say what you want, and then it's my turn to say what I have to say. So I read through all of that, and I've listened to what you had to say very carefully and what the lawyers had to say. And I was shocked when I read through your history, your criminal history. The number of assaultive offenses was, surprising to me. And even right up till fairly recently. And you've spent a lot of time, been on probation 6 different times. You had 14 prior jail sentences and 2 prior prison sentences. So this has been a long-running, long-standing issue. And so, while this incident in and of itself, although it sounds like from what I read in the report that, you were kicking the police officer here and physically resisting, it doesn't look like from the report that there were any injuries to the officer, but there certainly could have been based on the way that you were acting with the blood alcohol at 0.21. And so both your behavior in this case and certainly your past history, I think, would warrant a sentence, and the guidelines call for a sentence of up to 23 months in prison. So, and I think everything about what happened here and your past history wouldn't be unreasonable to impose that kind of sentence. It sounds like you're doing some good work right now to deal with this, and it's never too late. And so I hope that you're going to continue to work on this, because if not, you're going to go back to prison. That's all there is to it. There won't be any reason to not do it. I think in this case, anything other than a prison sentence is a substantial break to you. Minimum on the charge is 5 months. That's 5 months to 23 months. So the court is going to sentence you primarily because there weren't any injuries to the officer in this case. The court is going to sentence you to 9 months in the Crawford County Jail on that charge. Again, I think your behavior in this circumstance is more than warrants it. I think your history of assault offense is more than warrants it. For 19 days served. Charge. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees $50, DNA testing fee of $60, and $68 state costs. On the retail fraud charge, 30 days in the Crawford County Jail with credit for 19 days served, restitution of $19.39 payable to the Crawford County Clerk of the First Marathon Gas Station. $50 state cost, those sentences to be served concurrent to each other. You do have the ability to seek an appeal of this sentence. Mr. Thompson, can you provide those rights? Mr. Thompson, can you give me some papers that explain to you what your appellate rights are, Ms. Moore, as well as how to request a court appointed attorney to help you with the appeal?
You're going to initial this top one, we'll give it back to the court. You're going to get to keep the bottom 2 copies. If you wanted to file an appeal, if you wanted to file an appeal of the court sentence or your conviction, so you initial right there. We'll give that back to the court to see you got it. The other time, you keep 2 copies. If you wanted to file an appeal, you would fill out this card and turn it in. The first deadline's in 14 days.
Good luck to those courts. We have Mr. Ledesma present. All Ledesma versus State. 511875. Section 340 is now 340, or sorry, 330 is now 342. This was,
I do not see Ms. Ledesma.
And I don't think this PPO was ever served, Your Honor.
okay,
I could be wrong because I don't get the court file, but I don't have any documents that showed it was ever served.
so the court set this for a show cause based on a police report that was filed that came to the court where there was some alleged contact between Mr. Is it Mr.
It's Mr. Fitch and Miss Ledesma.
Petitioner, is that, you know?
Yes, August.
My nephew's name is August. I thought it was a male name, but I couldn't. Okay, so Miss Ledesma. No, it does not appear. Do you have any records?
No, Judge, so the PPO was granted, petitioner picked up the paperwork, never had it served, and then I got the show cause of violation of a PPO, sent it to your office, and then was set for today.
All right, so Ms. Coke, do you take any position on how the court should proceed?
I would ask that it be dismissed until it's served.
Okay, I think that's appropriate, given that the PPO was never served. Well, and it's gonna expire here, it looks like. Another month and a half, so. All right,
4-9.
so we'll dismiss the show cause and the court won't proceed any further on that. Yeah, it's 3:45.
Revisit Ackerman.
What?
Just give them
Did you want to revisit Ackerman? Or is that-
He didn't appear. Your Honor, do we need to revisit Mr. Ackerman? I can't remember if the court.
Oh, yeah, I'm sorry. Forgot all about it. Let's recall people versus Ackerman. Mr. Thompson, do you have any luck?
No, my staff attempted to call him at the phone number he confirmed this morning. We checked VineLink, which doesn't always update automatically. But we didn't see him in either. We didn't see him in a jail. I don't have an answer for the court. The court heard my earlier comments, so that's all I know.
Okay, Ms. Pope or Mr. Hayden?
No, Mr. McFarland was, prepared to go forward with a plea on the violation, so leave it to the court's discretion.
Yeah, I will confirm we had a plea set up for today.
Mr. Haven, I guess I'm just gonna ask that you let Mr. McCall requesting that you issue a bench warrant for Ackerman. He had previously absconded since October and was recently arrested. So I have some serious concerns, the fact that he can't appear today, even in light of the fact that he has had contact with counsel. So I'd like to do a bench warrant for a probation violation for his family to appear here as ordered by the court. And then we'll proceed further once we arrest Mr. Ackerman and have him in custody. Anything else in that, Mr. Thompson?
Nothing further.
Okay.
Nothing further. Thank you for revisiting that.
I gotta say for the record, Mr. David, this is your last day in court, so.
Yes, sir.
I didn't have anything prepared. I knew you were gonna be retiring. I didn't know today was gonna be your last day, so. I just want to thank you here on the record for your service to the court and the community. I've worked with you for the last 13 years that I've been on the bench, and I've always appreciated your professionalism in court, your professionalism out of court, the way you've always been prepared, ready with good recommendations for me, especially when I first started. It was important for me to have experienced agents with objective opinions. And over the years, I found you to be incredible asset to the court. And you're going to be missed.
Well,
but
thank you.
You certainly deserve everything that you've earned through retirement. I hope you have a wonderful
I
time
appreciate
away
all
from
the,
court.
And we're all jealous.
I appreciate all the guidance and direction you gave me when I have questions, and that's appreciated. I've learned a lot in this job. It's much different than working in prison, so. So,
So congratulations.
Thank you.
And, I'm sure we'll see you at your gathering, and I don't want you to say too much on the record. But I do want to congratulate you on your long service. Thank you for that.
You're welcome.
Yeah,
Thanks.